Good morning, everybody, and firstly, apologies for those who joined the live construction forum a week or so ago. As you'll know, I had significant technical issues and therefore I wasn't able to present my part of the session. Obviously, Steve Gummer did a great job talking through the latest in heat networks, and now hopefully you'll be able to hear my session on the building safety update. So let's get started. So, as you'll all be aware, the Building Safety Act changed fairly monumentally the building control process and has introduced for HRBs, high-risk buildings, which is currently defined as those that are at least 7 stories or 18 metres in height with 2 residential units or a hospital or care home, the requirement to navigate 3 critical safety checkpoints known as gateways. So gateway 1 is your planning stage. Before building works can commence, you have to go through gateway 2. And then before a building can be certified, complete and occupied, you have gateway 3. So this process is designed as a hard stop at each of those points until approval is received. So upon receipt of a gateway 2 application, the BSR is required to confirm if the application is valid, and if it is, to notify the applicant to that effect and determine that application within 12 weeks for a new HRB or 8 weeks for works relating to an existing HRB. And that time frame runs from the date of the relevant application. If the application is invalid, the BSR must notify the applicant giving reasons for its rejection. So as set out on the screen there, the BSR has given an indication as to the timeframes as they're operating in practice, because there have been delays. So in August 2024, they were advising to allow for circa 20 weeks for the gateway 2 element of the process. And in April this year, they were saying allow for circa 16 to 18 weeks. But we'll come on to the information that we've received around the actual timings of gateway 2 and gateway 3 applications and how many are getting through the process. So why the delays? So the BSR have cited a combination of factors. So they had a higher than expected number of existing HRBs that fell outside of the transitional arrangements, in a large part due to the insolvency of several private sector building control companies, which meant their cases moved across to the BSR. Delays in setting up multidisciplinary teams known as MDTs, largely due to a lack of skilled resource within the building control sector. In some cases, we understand that it's taking the full 8 to 12 weeks just to establish that MDT. And then also inadequately particularised applications with a lack of specificity in terms of building regulations compliance. So notwithstanding the BSR's guidance around timeframes, how long is it actually taking? Well, we have a much better indication now of whether that statutory timeframe is being met as a result of Alex Norris MP, the Parliamentary Under-Secretary of the State at the Ministry of Housing, answering written parliamentary questions. So Fulkers Bailey Russell, a consultancy, has analysed the responses, and here are some of the key statistics. So since October 2023, a total of 2,209 Gateway 2 applications have been made. From the information from those parliamentary questions, we couldn't determine which relate to new HRBs and which existing, but there has been an FOI request that I'll come on to, which provides a little bit more granularity. So of those 2,209 applications, 141 have been withdrawn, 208 rejected and 405 approved. So the overall approval rating is 18.3%. And of those approved, only 54 have been approved within the statutory determination period. So that's 2.4%. So the work that Fulkers, Bailey and Russell have done also shows that this year, 2025, only 1.5% of Gateway 2 applications have been approved and only 0.2 have been approved within the statutory determination period. So things appear to be getting a little bit worse, not better. In terms of the FOI request that I mentioned, so CAST, a cost consultancy organisation, raised an FOI to get data around the applications, and the response that came back showed that Gateway 2 applications for new builds, there have been 187 submitted. So the vast majority of Gateway 2 applications, being 2,049, have been for existing buildings. In terms of Gateway 3 applications, they've had 7 for new HRBs, none have been approved and none have been rejected as yet. And for existing HRBs, 80 have been submitted, 15 have been approved and none have been rejected so far. Cast Cost Consultancy went on to do an interesting piece of work looking at the average cost of applications. We will put a link following this session so that you can get a feel for those numbers, but just very quickly, in terms of a new HRB, they're estimating that the average cost of the Gateway 2 is £27,666. So a month or so ago, the BSR was looking at taking a firmer approach by rejecting more Gateway 2 applications outright in an attempt to kind of reduce and mitigate the delays that they're seeing. The current Chief Inspector of Buildings at the BSR, Philip White, who is due to step down in September, recently said that the industry needs to step up and comply with the process in providing good quality applications. The time we spend on those incomplete applications is time we can't spend on others, some of which would be perfectly good to go. That's what he said. And just referencing there on the screen, Unite have referenced the delays in the Gateway process, delaying their average build programme by about 6 months. And the British Property Federation have said that they've seen a 14% decrease in BTR homes as compared with last year as a result of the BSR delays. So it's having a real world impact, as many of us know. Just move on to my next slide. There we go. So what do you do if your BSR application has been delayed? So if the BSR needs more time to determine a Gateway 2 application, it can seek to extend the statutory time limit with the applicant. So that's allowed for under the HRB Procedures Regulations 2023. If that extension isn't agreed and the BSR has not decided an application within the prescribed time limit, the applicant can opt to use the non-determinations procedure under Section 30A of the Building Act 1984 to secure a decision, unless the BSR has notified the applicant that the application is invalid. However, the Section 30A process may not be a viable option for many applicants. This is because the non-determination applications made to the Secretary of State have no statutory time frame within which a decision must be made. And also, once you've made a non-determination application, you're not able to agree a new extension with the BSR for the case in question or request the non-determination process be stopped and returned back to the BSR for a decision. So once you've gone down that route, you have to stick on that track. In practice, given the uncertainty regarding how long a non-determination application under 30A would take, it seems unlikely that that procedure would be utilised particularly frequently. But for those who are experiencing extensive delays, they might give consideration to it. So in terms of the statutory guidance around the non-determination process, for those applications to be considered valid to receive a determination by the Secretary of State, they must also meet all of the following criteria. The original application submitted to the BSR must not have been, a decision must not have been issued within the statutory timescale or within an agreed extension, and no extension or further extensions have been agreed. The applicant must make the non-determination application to the Secretary of State within 6 weeks from the date after the expiry date of the original application with the regulator. And the applicant must inform the BSR of their intention to make a non-determination application to the Secretary of State. That notification must be given to the BSR at least 2 working days before submitting the non-determination application. So there's some process points there and specific timings that must be adhered to in order for you to validly apply under the Section 30A process, and worth bearing in mind if you are giving consideration to utilising that. So what's being done to address the delays? So most recently, as at the 18th of June, the House of Lords Industry and Regulators Committee, chaired by Baroness Taylor of Bolton, launched an inquiry into building safety regulation with a particular focus on the work of the BSR. The committee wants to hear from all stakeholders to find out if the BSR has the skills and resources required to ensure the safety of all buildings and their residents in the process of approving applications for HRBs. It's really crucial that this gets looked into if the government's going to achieve its manifesto target of building 1.5 million homes over the next Parliament. So what are the sorts of questions that inquiry is looking at? So they are looking at questions such as, has the introduction of the BSR improved the safety of buildings it's responsible for? What impacts could the framework have on the delivery of the government's housing targets? To what extent are delays in approvals for HRBs down to the regulatory process used by the BSR? Are the BSR's approval processes sufficiently clear and understandable to developers? Is the relationship between the BSR and building control authorities and inspectors working well? I think these are all completely legitimate questions and ones we probably are all very, very interested in seeing the answers to. So the committee is inviting written contributions by Sunday, the 31st of August this year, and they'll be holding public evidence sessions between June and September, and they aim to report to the House in the autumn. As stated on my previous slide, in parliamentary questions on the 7th of May, Alex Norris confirmed that MHCLG is exploring all possible options with the BSR to ensure it's equipped for the high demand of applications. It's also been confirmed that there's a roundtable that's been held, and the BSR is meeting weekly with the Construction Leadership Council. And on the 21st of May, it was confirmed that the BSR will in fact publish quarterly data demonstrating volumes of applications received, recorded outcomes and decision times for determination. So there will no longer be the need for submitting FOI requests going forward. So what else is new? Well, we've got new sets of guidance from the BSR published in March 2025, and there have been 4 sets which were published on the 27th of March. The expectation is that this guidance will help increase the quality of the applications being received by the BSR, therefore reducing processing times and rejections. So let's look at one of those sets of guidance in particular, which is preparing information for a building control application. So this guidance sets out the detail needed in each of the documents to be provided as part of a Gateway 2 application. It confirms that for new buildings which are complex, you may want to apply for a staged application. So this is when the building work is split into different stages. Each stage is treated and assessed as if it were an application for a separate building, and unless an extension is agreed, the BSR will take up to 12 weeks to assess applications for each stage, but at least it gets you going in your process, and perhaps you get your first stage approved before moving on to your next. If you want to make a staged application online, you have to submit how many stages there'll be, the estimated start and end date of the first stage, the name of the subsequent stages and their estimated start and end dates, and also upload a staged work statement. So given the delays already outlined, I'd suggest that those wanting to put in a staged application actually speak to the BSR well before putting that application in. The BSR delays and the added complexity of a project with staged applications to the BSR will need factoring into project timings, as will an ordinary application. So separately, in May 2025, the HSE published some guidance on the multidisciplinary teams, and they are particularly looking at local authorities for assistance under their statutory duties under the BSA in section 13. So the intended solution to the BSR's capacity problem was to outsource HRB reviews to multidisciplinary teams assembled from the private sector and local authority building control departments. Again, the BSR are taking much longer to assemble the correct teams, and so the guidance has been published, I suspect, with the intent that it helps streamline that process. However, the issue really stems from a lack of available resources in the first place. So the MDT guidance supports local authorities by advising on what they need to do when working to provide a relevant function as regulatory partners to the BSR. It states that they may provide their assistance directly to the BSR or through regional working. The BSR will contact local authorities without regional working arrangements directly. There will be memorandums of understanding detailing those MDT arrangements to ensure the collaborative working as between the BSR, Local Authority Building Control and London District Surveyors Association. And the BSR will lead and support MDTs, and assistance from local authorities may involve plans assessment, assessment of building control approval applications, inspections, the assessments in relation to completion certificates and such like. It will be very interesting to see how many local authorities actually have capacity to help the BSR. And if they don't have capacity, they actually have to set out their reasons for this in writing to the BSR as part of their response to such a request. So next, we're taking a look at roof gardens. So the case law and guidance is still evolving, and this is evidenced in the FTT case of Smokehouse and Curing House. Regulation 6 lists items which will not constitute a story, including a story which is a rooftop machinery or rooftop plant area or consists of exclusively of rooftop machinery or rooftop plant rooms. So there is no definition of a story per se, and no reference in the definition of HRB of how rooftop gardens in particular are to be considered. But the guidance goes further. And it states that a story must be fully enclosed to be considered a story. The roof of a proposed building should not be counted as a separate story. Open rooftops such as rooftop gardens are not considered stories and should not be counted as such when determining the number of stories or measuring the height of a building. It should be noted that that isn't statutory guidance, it's just the guidance that sits alongside the regulations. So the FTT provided its analysis of whether a roof garden was a story and found that it was. However, the upper tribunal recently criticised that decision in terms of the confusion it's created amongst building safety professionals. The key takeaway here being the building safety legislation is still changing and needs to always consider the legislation and regulations first before you consider the guidance. So in the Blomfield case, in which they determined that a story included a rooftop garden, the FTT decision included a lengthy discussion as to whether the building was a HRB, as well as the meaning of the word story and the status, authorship and accuracy of government guidance. In particular, in relation to rooftop gardens, the FTT expressed the view that government guidance notes on the definition of a HRB during design and construction and during occupation contradict the statutory provisions. And they noted that whilst they had no formal jurisdiction to make this declaration, they nonetheless stated that the FTT considered that the building was a HRB and therefore should be registered with the building safety regulator and have a principal accountable person appointed. So really what they did was highlight the disconnect between the HRB regulations and the government guidance published online. Sorry, just to note that the MHCLG produced an update note in May 2025, and as referenced on the screen, they've stated that they're consulting with the building safety regulator and other relevant stakeholders on a proposal to amend the HRB descriptions and supplementary provisions regulations to make it clear that roof gardens should not be considered a story when determining whether a building is a higher risk building. So on to the government's first progress report on the Grenfell Tower inquiry. So phase 2 recommendations from May 2025. So the government accepted all of the inquiry's findings and will take action on all 58 recommendations. They will publish progress reports quarterly until all recommendations have been implemented, and they expect that to take at least 4 years, mainly because of the need for primary legislation, which is subject to parliamentary time. So just looking at a few of the items on that timeline there. So just starting with the Construction Product Reform Green Paper. So consultation closed on the 21st of May this year. Construction products, as stated in the consultation, represent around 12% of the UK's entire manufacturing base by turnover. Total sector turnover is estimated to be around 79 billion, and there are approximately 24,900 construction product manufacturers in the UK in 2023, representing around 1 in 6 UK manufacturers. So the issue in terms of those products is that the current regime in the UK is based on retained EU law, which, when it was originally conceived, principally aimed to remove technical barriers to trade rather than ensuring safety. So construction product regulations in the UK currently only apply to products for which there are designated standards. This leaves around 2/3 of all construction products on the market unregulated. And it's also considered that enforcement action in respect of construction products is insufficient. So in terms of reform, there's looking to align that UK position with the EU's objectives in their recent and ongoing reforms. So what they want to do in terms of those unregulated products is to create a proportionate risk-based system which focuses on safety to bring those unregulated products into a regime in a proportionate way. There'll be testing and certification with zero testing houses to be licensed and a statutory code of conduct overseen by a regulator. A construction library for information on products and how they're to be used, although there's obviously some discussions to be had around the difficulty on maintaining such a library. And then in terms of enforcement, potential new powers, including surveillance powers and exploring fines and criminal action, which again would sit with the regulator. So residential personal emergency evacuation plans, or PEEPs, as they are referred to. So PEEPs will mandate that a building owner or manager engages with their vulnerable residents, considers how to improve their fire safety and evacuation, and enables all residents to understand what they should do in the event of a fire, give fire and rescue services information in case they need to support their evacuation, and mandate building level evacuation plans for these buildings. So the Fire Safety and Residential Evacuation Plans England Regulations 2025 were laid in July and mandate residential PEEPs and mark a long-awaited step forward in improving the fire safety and evacuation of vulnerable residents. It applies to residents living in England in high-rise residential buildings at least 7 stories or 18 metres high and 11 metres to 18 metres high buildings with a simultaneous evacuation strategy. As we understand it, guidance will be produced in respect of these regulations following input from stakeholders on the draft, including disability groups. And the government will be developing a toolkit to support responsible persons in their implementation of residential PEEPs. So next, the Independent Panel on Building Control. So the Independent Panel is a panel of experts chaired by Dame Judith Hackett, and they are providing analysis and advice to the government on the 2 questions in the Grenfell inquiry final report relevant to the future of the building control system in England. So these being 1, whether it's in the public interest for building control functions to be performed by those who have a commercial interest in the process, and 2, whether all building control functions should be performed by a national authority. So that panel is working with MHCLG, the BSR and stakeholders, and they will gather evidence on the prevalence and impact of conflicts of interest and capacity pressures affecting the building control system in England. These issues were identified by the Grenfell inquiry as reasons for building control failures in the run-up to the Tower fire. And this work will consider conflicts and capacity in both the private sector and local authority building control sectors, looking to establish whether these are still present and what options should be taken to address them. Next in the timeline, definition of HRB. It stated that they're currently working with the building safety regulator to agree the criteria and content of the ongoing review. We expect the review to include the consideration of known issues within the built environment and activities that would allow the identification of further risks. And the building safety regulator will set out plans for review at the end of summer. Next, the single construction regulator. So consultations for recommendations such as the creation of a single construction regulator and the College of Fire and Rescue will begin after the summer. These recommendations must go through consultation before they are considered for legislation. And approved document B. So the BSR has developed their plans for the review of how statutory guidance currently offered in the form of approved documents. This includes engaging widely across the sector to establish a panel with the right expertise and diversity to oversee the review. And the building safety regulator continues to engage with the sector and review relevant recommendations and issues raised through the inquiry's report, alongside research outputs of the ongoing technical review of approved document B, towards publication of consultation on further changes to approved document B in autumn 2025. So we'll be looking out for that. And then advisory panels. So there's the creation and appointment of a number of new positions and panels, which shows progress towards a number of recommendations relating to regulation of professionals, including the new Fire Engineers Advisory Panel, which is expected to consider what should be expected of a competent fire engineer, and the independent panel on building control, which I have just referenced. And then the Chief Construction Advisor, the CCA, this will provide independent advice to ministers working with government and industry to rebuild trust within the built environment. So they'll work closely with industry to drive change across the sector. The interim CCA will work on priority areas. So that will be design and implementation of a single regulator. And they anticipate having the permanent CCA appointed in 2026. The first interim is to be appointed imminently. So the government has announced some building safety regulator reforms, and the intent here is to enhance operations, reduce delays, and unlock the homes this country desperately needs, delivering on their plan for change. So some of those reforms, which don't appear on this timeline because they occurred after we produced it, include a new fast track process to bring the building inspector and engineer capacity directly into the BSR to enhance processing and review existing new build cases and remediation decisions. The addition of 100 new members of staff to support the enhancing operations, hopefully to reduce delays. And Andy Rowe, KFSM, has been appointed as non-executive chair of a new board of the Ministry of Housing, Communities and Local Government, MHCLG, to take on the functions of the BSR as part of initial steps towards creating a single construction regulator, i.e. a move away from the HSE. So Rowe's previous role was Commissioner of London Fire Brigade, and he will be supported by the LFB's Deputy Commissioner, Charlie Pugsley, who will take up the role of the new Chief Executive Officer of the BSR, i.e. Philip White's replacement. So they had initially said that they were in the recruitment process, but we now know that that's who the replacement will be, and we will provide a link to the press release for you. Now, finally, I'm conscious that I am running over my time. We come to the BSA working group. So the stated aim of the working group is to seek to provide some consistency of approach to issues that arise as a result of the enactment of the BSA, whether that be in the Technology and Construction Court or the First Tier Tribunal. So this includes considering what areas in particular are causing concerns to practitioners and how those issues might be addressed. So the group has created an online database for relevant BSA case law from both the FTT and the TCC. They have suggested changes to the TCC guide, such as requiring parties to make plain that they have a BSA related claim at the beginning of the process. They have proposed a scheme for co-managing BSA cases that span or overlap in both the FTT and the TCC, which will alert judges to case management issues and help improve procedural efficiency. So this proposal was submitted to both the President of the King's Bench Division and the Senior President of the tribunals. And the group has also sent out a questionnaire to stakeholders, which has raised a number of further issues for review, such as consistency in application of the BSA across the tribunals. And the new TCC guide is expected to be published soon to tackle all of the above. So the main issue being that, as stated on the screen there, that FTT currently considers remediation orders and remediation contribution orders, whereas the TCC deals with building liability orders. So there's a need to kind of make sure that there is consistency across, with the suggestion that perhaps one of the TCC judges will sit within the FTT, we understand. So that was a whistle-stop tour of the building safety updates for you. Again, apologies for my initial technical issues. I hope you found that informative, and of course we will be keeping an eye on all of the updates in this area. So watch out for our blogs, articles, and latest updates, and of course we'll cover those off in future construction forums too. Thank you, everybody.